Good morning, everyone. You're very welcome to our conference on environmental assessments. And we are going to try to establish a multidimensional dialogue about this theme. I would like to thank everyone for being here presently, for the ones who are listening to us, for the speakers who are online, and the speakers who will be here with us, like Professor Edwin Alblas, who will speak in this panel. This is our annual environmental conference of our research center. Since 2008, we try to have one environmental conference a year. And so on 2024, this will be our environmental conference on environmental assessments. We have a first panel about environmental assessment in the Court of Justice of the European Union. This is our first panel in the morning. I'm here replacing Professor Eloise Oliveira, who should be the chair today because she is having some health problems. We all hope she'll recover very soon. And I'm trying to replace her the best I can. And I will present our first speaker, who is Esperança Mialha. I hope she's with us right now.
I am. Good morning.
There she is. Esperança is, above all, a very good friend, and I am very happy to see her, even if in a long distance way. How are you, Esperança?
I'm fine, thank you, Carla. Very nice
It's
to
fine.
see you,
Yes,
even
not speaking
from
right
a
now.
distance.
So Esperança is a master in law, and she works as a lecturer. She worked as a lecturer at the University of Lisbon. In ancient times, she was lecturing family and succession law, but then she she worked as a legal consultant for the Directorate General for Higher Education and as an advisor of the Secretary of State for Higher Education. Then she turned to be a judge, and she worked as a judge in the administrative jurisdiction for some time. And presently, she is in the EU General Court in Luxembourg. She works as a referent there. And it's in that quality that we are going to listen to her talking about environmental assessments in EU jurisprudence. And dear Esperança, the floor is yours.
Okay, so good morning, everyone. Greetings from Luxembourg to Lisbon. It's a pleasure to be back to my university. I want to greet my fellow speakers, Professor Kramer, Professor Albas. I'm sorry, Professor Luís Oliveira couldn't be present. I wish her fast recovery. And a special thank you to my dear friend, Professora Carla Amado Gomes, for the invitation to participate in this conference. So we're going to take a look at some recent European Court's case law on environmental assessments. First, let me give you some statistics. These are all environmental cases, not only, of course, impact assessment cases, between 2018 and 2023. As you can see in the graphic, there was a significant drop in 2 years. It was COVID years, but now we seem to be back on track. There are, of course, much more cases before the Court of Justice than before the General Court. Although nowadays I can say that the General Court is dealing with some very important cases, namely with the taxonomy cases. However, regarding environmental assessments, these are cases that are always put forward before the Court of Justice. And before starting with the cases themselves, let me remind you that there are different types of proceedings. And of course, we have to keep in mind which type of proceeding we are so that we can better understand the case law. Regarding environmental assessment, there are two types of proceedings that can be involved. Generally, it's a preliminary ruling when a national court puts forward a question to the Court of Justice regarding interpretation of EU law. And also there are actions for failure to fulfill obligations. These actions are brought by the Commission against a member state when the Commission considers that said member state is failing to fulfill its obligations. And we will start exactly with 3 examples of actions for infringement brought by the Commission against member states. These are 3 recent ones. There are much more over the years. The Commission acts here as a kind of treaties guardian, looking for obligation of complying with the rules. So the first case, Commission against Poland, the Court of Justice has declared that Poland has failed to fulfill its obligations under the EIA Directive of 2011, insofar as Poland legislation had excluded projects to locate or search for shale gas deposits. Shale gas, it's a form of natural gas, from the procedure for determining whether an environmental impact assessment is necessary. So this kind of activity was upfront excluded from impact assessment. The second case, Commission versus Ireland, is a case where the court orders Ireland to pay a pecuniary penalty for failing to comply with a previous judgment from the court, in which in this judgment from 2008, the court had required that an environmental assessment would be carried out in respect to a wind farm. So these actions for infringement, they have 2 phases. First phase is the court will establish if there is a failure to comply. Second phase, if the member state does not comply with the judgment, penalties, pecuniary penalties can be imposed on the said member state. The last case interests specifically us, Portugal. It's a pending case. The Commission has filed an action against Portugal with 6 pleas of law because the Commission estimates that Portugal has not fulfill its obligations regarding several articles of the EIA directive of 2014 version. So because it's a pending case, I will not comment further, but we have to keep a closer eye on this. And now let's go for environmental assessment of projects. Because it's a very specific situation. It regards the public participation during the environmental impact assessment procedure. In this case, the project to be assessed was located in one of those islands that are marked there in Greece. It was in Lodz Island. And the file and the notice for participation, for public participation, was in the other island, Cyrus. And so these 2 islands in this little map, they distance something like 55 nautical miles. And the court said that when the public is not put in a position to actually participate in the environmental impact assessment for a project, a time limit for bringing proceedings against the decision cannot be relied on against the public. This was in the court's view, this case in hand. Not likely to repeat because, as I said, it's very specific for the Greek islands, but I found it very interesting. The next case regards a renewal of an already existing project. And it's the 2 nuclear power stations in Belgium. There was a law extending the operating life of those power stations. And as you can recall, normally the Court of Justice estimates that when we are talking about extending of already existing activities, we don't need to go through a new impact assessment. But in this case, the extending of the operating life was accompanied by major works to update the nuclear power stations. So in this case, because of the works involved in the potential impact of the said works, the court estimates that it is compulsory to subject this law to a previous impact assessment. Also interesting about this case is that the court acknowledged that the effects of the annulment of this law can be provisionally maintained if there is a serious threat of an interruption to electricity supply in Belgium. And in the aftermath of this Court of Justice decision, the Constitutional Court of Belgium, which was the national court putting forward the questions, did decide in this sense, in a decision, I believe from 2020, if I'm not mistaken, it did annul the law for lack of impact assessment, but it did maintain its effects for a time being because of the threats of problems with electricity supply. The next case regards an ex post impact assessment. This was a case with questions put forward by the Danish court to the Court of Justice regarding the need or not of an impact assessment in a case of renewal of a permit for a fish farm. The Court of Justice held that normally impact assessment for a permit or which exists already is not necessary. However, in the present case, the first impact assessment had not been correctly done. Namely, it had not took in consideration the potential effects of this activity on a nearby Natura site. So, because of this situation, an ex post impact assessment is necessary and we'll have to consider all elements, including new law developments. I don't know the outcome of this case, but one of the possible consequences might be that the fish farm, which had existed since 2006, sees its permit refused for not complying with the current requirements. And for our next case, we go to Vienna, Austria. This was a construction project which implied demolishing an existing hotel and building several new buildings. And it was to be done in an UNESCO World Heritage Site. The problem who raised doubts to the Austrian courts and then motivated the referred to the Court of Justice was that according to Austrian law, this project was under the thresholds that were laid down, but those thresholds related to land taking and gross floor area and did not consider the location of the project. So the court answered that the EIA directive precludes national legislation from fixing unique thresholds based only on land taken gross floor area and disregarding other factors such as nature and location of project, which of course was a big issue here since, as I said, this was located in an area classified. This judgment shows and is linked to a long line of jurisprudence from the Court of Justice, which started very early in the day, stating that member states don't have unrestrained margin of discretion regarding the screening of projects falling into Annex 2 of the EIA directive, so they cannot set up criteria and thresholds as they wish. Those criteria and thresholds must respect the ratio and the objectives of the directive. Next case concerns the exploration of petrol and natural gas in the region of Puglia in Italy. In this case, there were several permits accorded to the same operator for exploration of these hydrocarbons. And the Court of Justice held that this national legislation could allow granting the same operator more than one permit for adjacent areas that together covered more an area that would exceed the limit for prospecting authorizations, and that would be conformed with EU law. However, this situation was subject to two conditions. First, it would have to be ensured there was no discriminatory access to those activities, so they have to be transparently open to all operators. And secondly, which concerns more our subject, it would be necessary to take into account the cumulative effects of projects to avoid to circumvention EU legislation by splitting up the set projects. So the impact assessment would have to take into consideration the nearby activities as well. Splitting of projects in order to avoid impact assessment is of course well known, and there are several criteria for identifying the splitting of projects. I don't have time to detail it, but this is just another example of those situations. The next slide concerns cumulative effects with existing projects. Again, it's not just to look at one isolated project, but to see how it inserts on the nearby projects. Here it was the construction of a building for the rearing of chickens, and it was next to other similar installations that already existed. However, those installations had no joint facilities, and apparently, according to German law, this was a case brought by a German court, the limit, the evaluation of cumulative effects for similar activities demanded that there was a common project, that there were joint facilities, which was not the case, as I said. The Court of Justice said that the obligation to evaluate a project impact jointly with other projects could not be limited to situations in which the installations already existed are linked by joint facilities. Also, I should point out that this is an order here and not a judgment. And that is because the answer to the question referred to the court, the court found that it could be clearly deduced from existing case law. So much non-formal procedure is adopted as an order. And now I have two other cases now regarding strategic assessment of plans and programs. The first one, it was at stake an order from the government of the region of Wallonie in Belgium, and that order defined a urban land consolidation area. And here the Court of Justice adopted a broad concept of plans and programs to include this order in this concept, estimating that the fact that you are adopting an urban land consolidation area means also that it is possible to derogate from certain planning requirements. So this order would have to be submitted to strategic assessment. Also, the courts underline in this judgment that an assessment of the effects on the environment carried out under the EIA directive cannot lead to an exemption from the obligation to carry out the environmental assessment required by the CEA directive. This is something the court has repeatedly underlined. And the last case concerns a wind farm in Belgium also. This was an action brought before a Belgian court by residents of several Flemish communes where it was planned to be installed 5 wind turbines, and there had been no strategic environmental assessment. The Belgian court had doubts, and answering those questions, the Court of Justice stated that in fact, he had the opportunity to go back to its interpretation of the concept of plans and programs, and it decided not to revise its settled case law about this, continuing to adopt a very broad concept of plans and programs that are subject to strategic assessments. There was at the time of this judgment already some divergence between the court's position and, for instance, the conclusions of the Advocate General Cocotte regarding the same issue, but the court stayed on the same track of this broad interpretation. Also, in this judgment, the court answered the question of whether and under what conditions it might be possible to temporarily maintain the effects of any annulment of plans and program, as well as individual decisions adopted on their basis. And with this, I conclude my presentation. Thank you so much for your attention.
Thank you very much, Esperança, for your presentation. I would now give the floor to Professor Ludwig Kramer, who I expect is with us right now. Yes. Hello, Professor. Good morning. Professor Ludwig Kramer is a friend of our faculty. He has been here several times. He has made significant contributions to environmental law at various levels. He served at the European Commission, heading units focused on legal affairs, waste management, and environmental governance. Throughout his long career, he has offered numerous publications and over 150 articles on environmental law. He's a visiting professor at University College London, a professor in European and German environmental law at the University of Bremen, and he's also a professor at the College of Europe in Bruges. Professor, it's so good to see you. You're very welcome to our conference, and the floor is yours.
Yeah, thank you very much, Professor Gomes. Can you hear me?
Perfectly.
I just wait for the organizers to open the... There we are. I am a little bit following up to what Dr. Merja said a moment ago, drawing the line from the European Court of Justice on environmental impact assessments, which is quite amazing. Next year, we will have the 40th anniversary of this European legislation. And it is worthwhile mentioning that because when the directive was first adopted in 1985, there was literally no legislation in the EU member states of that time. France had just adopted legislation, but and followed a little bit the United States preliminary law on environmental impact assessment. But all the others and certainly not either Portugal and Spain had no legislation. This means that the European level shaped form and content of the environment impact assessments. And we have, in fact, overall, 4 different types of environmental impact assessments. The first is the broadest one, the Strategic Environmental Assessment for Plans and Programs, adopted in 2001, 42. The reason for adopting this directive was that the second directive of 1985 and then substituted by the directive of 2011 asked for environmental impact assessment for certain projects, but it turned out that member states very often had fixed the content of projects and the dimension and location in plans and programs which they had adopted at national or regional level. So they bypassed the requirements of Directive 2011-92 and made necessary that there be a specific legislation on plans and programs. I will come back to that issue. The third issue for environmental impact assessments is for natural habitats, the Natura 2000 projects, laid down in directive from 1992. And the difference between the environmental impact assessment for projects and for habitats is that when an environmental impact assessment for a project is negative, and thus says that there is a significant negative impact on the environment, the project manager may nevertheless go ahead. It has to look for compensation measures and mitigation measures, but the project itself is not barred and prevented from being realized. When a project under Article 6 of the Natura 2000 directive shows that there are negative significant impacts on the habitat, the project may not go ahead. It may only go ahead if there is scientifically exclusion that there be negative significant impacts. It is true that there is an exemption clause from this strict requirement in Article 6, paragraph 4, which allows in exceptional cases for the realization of the project for major public interest reasons and against compensation. But this is an exceptional case. The normal issue is that the project may not go ahead. Finally, we have an environment impact for European legislation, and this is a potentially important aspect. Until now, we had only one case, and it was based on the interinstitutional agreement on better regulation between the European Parliament, the Council, and the Commission. This agreement said impact assessment should assess the economic, environmental, and social impacts of legislation. And since 2016, the Commission makes its proposal for legislation be accompanied by impact assessments. It is true that the environmental impact assessment of legislation is very often rather poor. It is not quantified. It is rather going on qualitative aspects. But nevertheless, there is some assessment. Next slide, please. Have a look at the number of cases before the European Court of Justice. Dr. Melia already mentioned a number of recent cases, but I took the numbers from 1985. For the Plans and Programs Directive, we have 21 cases where the court gave judgment. The main bulk of the number of cases was the directive on projects, where the court delivered 76 cases. you see here what Professor Merlia already had mentioned, that the cases under the Projects Directive may be initiated by the Commission. That is Article 258 of the Treaty on the Functioning of the European Union. Either thus by the Commission or by a member state with a preliminary judgment from a national court. Whereas the Directive 2001/42 does not find practically any case law which has been brought by the European Commission. I omitted to mention some small cases where a member state was late in transposing the directive, but this is not really relevant here. Cases under Directive 92/43 are limited in the amount because the impact assessment does not play a very important role. Member states are keen to make some sort of an assessment, but then nevertheless try normally to go ahead with the project even where there are negative impacts. Again, the Commission is a sort of watchdog for making sure that Article 6 is respected in in procedure and in substance. Under the Better Lawmaking Agreement, there's only one case which has been brought until now. In 2017, Poland complained that an environmental legislation had not been taken into consideration the impact assessment, economic, environmental and social of climate change action, which impaired the interests of the Polish coal industry. The court came out with a judgment that Poland itself had delivered the necessary factual information, and therefore it could not complain on incomplete or incorrect assessment of these data, and therefore dismissed the complaint. Please, next slide. Here I listed a number of decisive decisions by the European Court of Justice. The first one, and one of the very first on environment impact assessments, concerns the question whether the impact assessment directive may be raised by the national court ex officio, or whether it can only be done on complaint by one of the parties. And the court said that this depends on the national law. In the case in question, the Dutch legislation provided that the court could take up such a case, such an issue, and therefore this Kreyerfeld case was finally assessed by the national and by the European courts. The second issue is that member states until the 90s were used, and I think also the Portuguese government, were used to issue plans and programs and environmental measures by ways of administrative circulars, not by legislation which had normally to pass Parliament. The court said that the directive on environment impact assessment gave rights to citizen and to business, and therefore legal certainty required that this be passed by legislation of national lawmakers and not just by circulars. In case 2 of 2007, the court held that an environment impact assessment had to be made for a project when it made a physical interference with the environment. So the extension of, for instance, takeoff and landings for airplanes was not a physical interference and therefore did not require an environmental impact assessment. But when you made a longer runway for the airplanes, this was necessary. The legislation on exemptions by national rules was considerably shortened down by the European Court by saying that the legislation which exceptionally provides for an exemption, which is possible, must necessarily be as detailed as a permit consent. And this is a very, very strong restriction of the field of application of exemptions. Dr. Mealia mentioned already for the Annex 2 projects that it is not just the dimension of a project, it is also the location and the nature of the project which is determining. And where a project only takes into consideration one of these issues, it falls short of the requirements of the directive. Relevant for citizens is that the absence of environment impact assessment, which is possible for particular Annex 2 projects, because the national administration might consider that there is no significant environmental impact, that they must give reasons to the citizens on request of the citizens. And when no reason is given, the citizen may go to the court as an access to justice case. This means that private persons, citizens, neighbors, environmental organizations may invoke the protection granted by the Environmental Impact Assessment Directive, which is a very relevant issue. The jurisprudence on the direct effect of European law is in particular meant to protect citizens. I will pass on the splitting of projects, which Dr. Mealia has already mentioned. The sanctions for environmental impact assessment, sorry, could you go back to the sanctions for the non-requirement of an impact assessment are for the national law. But the court had made quite a number of conditions on that. The sanctions must be proportionate, and the sanctions may not be restricted to maintaining the effects of the project as such. They must have some effect on the ground. And the burden of proof that an environment impact assessment would have made another decision cannot be placed on the citizen. The administration must itself see that it corrects its original projects. Ex post environmental impact assessment was already mentioned by Dr. Mealia. What is important in the last issue, which had also been mentioned, is that the directive in its original form did not talk of demolition of projects. It just talked of new projects to be made, and the extension that the directive applies to demolition of projects is an extension made by the European Court of Justice and has now been inserted into the directive itself. Next slide, please. There are less cases, as I mentioned, for the Plans and Programs Directive. The court has held that an impact assessment for a project, there's an error in the slide, for a project does not make a strategic environmental impact assessment superfluous. And the court has further held that an amendment or modification of a plan also comes under the directive, which is not in the directive itself. It is jurisprudence by the court. The same applies to the urban development plans, which were with difficulties to be subsumed under the original text of the directive. But the court inserted that. That means that all projects for Lisbon development and all plans for Milano or Roma or Paris development must be preceded by an environmental impact assessment. German law had provided that a plan without a strategic environmental impact assessment may be maintained valid for urban development, but the court annulled that German legislation. A very important issue is that the court, the directive originally declared that it would only be applicable when a plan is required. But the court said required means when the authorities who adopt the plan are determined and there are provisions on the way of how to adopt the plan laid down in the legislation, then the plan is required. And this enlarges the field of application of the directive very considerably. Again, compared to the project, the splitting of plans is not allowed. We had the case just mentioned on the Italian exploration at sea case. And the exemption for small plans refers only to local plans and size, not to regional plans or national plans, which are considered to be small. Again, a restriction which is welcome because it clarifies that the strategic environmental impact assessment is the rule and not limited to significant plans. Next slide, please. Under Article 6 of Directive 92 of the Habitats Directive, the court clarified that an environmental impact assessment under the Impact Assessment Directive cannot replace the assessment under the Habitats Directive, because the Habitats Directive means to protect definitely and determinedly the habitat, the natural habitat, whereas the environmental impact assessment is more procedural directive, which only wishes that the administration has knowledge about the impact assessments without protecting the natural environment. Therefore, the assessment of a project allows the project to go ahead only when there is no scientific doubt about the harmlessness of the project. The court said in a number of judgments that a continuous activity may also be a project. This was given in a case where Dutch fishermen made fishing in a natural habitat year by year, and they had a permit every year. And the court said, this is a project, which never the Dutch authorities had considered. The relevant issue in the next case is that the cumulative effect shall be taken into consideration. And on this, the directive says that the direct and indirect, the temporary and permanent, the small, medium, and large impacts shall be assessed, which is very large extension by the Court of Justice of this requirement. Next, please. What do we learn by all this? The European Commission plays a subordinate role in bringing cases in these issues. We heard from the Portuguese case, which was brought, but only because there's an incorrect transposition. The application, the actual application, is not monitored by the European Commission. This has to be done by member states, and if it's not done, the environment remains unprotected. We have no case under Article 258 initiated by the Commissioner for the Planning Directive. And the interpretation of the meaning, the importance, the impact of the law is given to the European Court of Justice, not to national courts, and therefore we have these numerous 267 cases. The European Court is environment friendly throughout. I think there are very few directives, very few judgments where the court was in favor of the economic interests which were behind the project. You saw a little bit with the Belgium nuclear case that the emergency clause which the court invented in that case is practically leading to a diminished degree of protection of the environment. But that the perfection is not of this world. Sanctions are only foreseen in Directive 92/43 in the Habitats Directive. Neither the Impact Assessment Directive for projects nor for plans and programs provides for sanctions. And this means that the application, the actual application, the implementation of the two directives remain the big problem of application of this legislation. They are important projects of legislation for the national lawmaker. And the courts are reluctant to make extensive interpretations of these directives. Therefore, the role of the Court of Justice is so relevant. We have no European rules on golf courses. A golf course uses water for about 15,000 people. And therefore, it might well merit an environmental impact assessment, but this is left to national law due to lobbying activities at European level. Snow producing plants is the same issue. And the last issue, that EU plans and programs are not really covered. What happens at European level in climate change issues, in energy-related issues, is not really covered by environmental impact assessment directives. I think that brings me to an end of the lesson, of the lecture. Thank you very much for your attention.
As involves biodiversity, agriculture, soil, health, nature conservation, we do focus on environmental democracy. His teaching covers environmental law and policy, environmental politics, and regulatory governance. Only this? Oh. Thank you very much, Professor Edwin. The floor is yours.
Thanks so much. Such a pleasure to be here today. I'm really grateful for the opportunity and also to be here in real life. I have some slides prepared, so I don't know if they can also be on the screen. Okay, so thanks for the introduction and good morning, everyone. My invitation, when they invited me, they asked me to do more of a theoretical exploration of environmental impact assessments. So why do we have this system? Does it work? And I don't have any final answers on these questions, but I did want to provoke our brains a little bit. And to do this, I've borrowed a lot from other disciplines, including behavioral sciences, because I think that environmental impact assessments are all about decision making, decisions by the people making the impact assessments, what to include, what kind of calculation methods to use. And then the decision maker, of course, they'll have to make a decision based on an environmental impact assessment. So I thought it would be interesting to borrow a little bit from the behavioral sciences about how we make decisions in our real life. Okay, I've adopted a very simple structure. First, I'm going to look at the why of environmental impact assessments. Why do we have the system in the first place? What are we trying to achieve? It was set up in the 1980s, and now it's 2023. The world looks quite differently, so is this still fit for purpose? Then I'm going to look at the how of environmental impact assessment. So how have we given this shape? How does it work? Might there be problems or issues with the current system? And then finally, I'll try to sketch some possible routes forward. There's two disclaimers I want to make. First of all, my research and my experience is based mostly on the Dutch context in the Netherlands, and this might be quite different from your experiences, but hopefully we'll be able to learn from each other. And I think, quite sure, probably many of the experiences will relate. And then secondly, this is still very much ongoing research. There's no final answers here. And hopefully in the discussion, we can also bounce forth a little bit. Okay, I'm the third presenter, so I thought I would start with a bit of an icebreaker to get you all awake and alive. As I said, we're talking a lot about decision making, and in behavioral science, a key concept is heuristics. You might have heard about this concept before. But we're confronted with so many decisions in our lives and we have to process all these things, which is very difficult. So what our brain does, it builds all these shortcuts in our mind. And these are heuristics that help you make decisions more quickly when you don't have all the information at hand. And the situation when you often need heuristics is, of course, when you're planning a holiday. Portugal is for many seen as a holiday country, but planning holidays is for many people very difficult because you have so many things to decide. Now, one very famous heuristic is the familiarity heuristic. This is something that a lot of people do. So let's say I have two sandwiches. One is a sandwich I eat every day. One is a Portuguese sandwich that might be much better than my Dutch sandwich. Often people still go for the one that they're familiar with because you know it, you trust it, etc. That's one way that we make decisions very easily. We trust what we know, even it might not be the best thing. So as an icebreaker, I wanted to ask you if you can guess the percentage of British people, so British people, that choose the same holiday destination every year. So every summer they go to the same place. What do you think the percentage of British people is that does this?
50%?
So you say more than 50. What do some people in the audience think? 80% of all British people who go on holidays go to the same place. Anyone else?
So average all holiday goers they did at home. It's not a it's not a perfect model. They did a study when they asked the average British people or everyone who goes on holidays anyways. So if 80% is 50, it's actually 75%. Go to the same exact place every year because it's right? You have familiarity, you might have the space. It will probably not be the best places, but actually one British people go to Spain, Portugal. So it might be the best thing, but no way to be trusted, and that's one way that people are things. That's what. Yeah, that's the conference. And when we make decisions, we have a lot of statistics, a lot of examples, and we have a lot of biases. So you know, might be the best choice, but there's no easier, and this will in many ways also different. Okay, let's start with the why. The why do we do it?
When you read the directive, it's very simple. Just to ensure that before we have a consent by a decision maker, we want to make sure that there's an assessment. That's it in the core. We just want to make sure that we've assessed what will happen or what can happen. Because in the 1980s in the US, was there something with the sound in this entity? Oh, it's okay now. Yeah, super. In the US in the 1980s, there were a lot of projects and plans that had huge environmental disasters as a result. So people wanted to know, okay, if we do certain things, what will be the effects? So that's it in a nutshell. Then the Court of Justice, over time, when they implemented the system in Europe, has added that it's not just an assessment, but we're really trying to achieve the protection of the environment and the quality of life. Yet there's no mandatory balancing of different considerations. So it's not really, if there's a very large environmental significant effect versus a good economic effect, a decision maker doesn't have to weigh those different interests when he's making a decision. And there's also no environmental stop button, like what we had with appropriate assessment, what Professor Kramer said. If there's a huge environmental disaster that might happen when you build a certain airport or build a certain data center, still the project can go ahead. Is this enough? So again, as I said, the system was set up in 1980s. Now it's 2023. Is this enough? I would say that we know so much now about our environmental footprint, about what we're doing to this planet, that you might wonder if this is indeed enough, and whether if an impact assessment shows that there's a very large and significant impact, whether we should not stop the project altogether. So if there's a plan for an airport and it shows that the impact will be huge and very significant, maybe the decision maker should then say, okay, let's not do it, instead of saying, okay, nice to know, but we'll still do it. There were also requirements before, for instance, in Dutch law that said that an impact assessment, the person who makes the impact assessment has to find the most sustainable alternative and present this in the impact assessment, but that has been taken out to harmonize the EU requirements. So you could really wonder if this is enough. as we're in a climate crisis, we're in a biodiversity crisis. I would say that maybe impact assessment should do more than just assess, but also like we have with the Habitats Directive, put a stop on projects if they're too, if they have too big of an impact. Okay, and then the how of environmental impact assessment. So how do we do it? What is our process? In the law, it just says that a competent authority has to carry out these reports. This can be a planning authority, an environmental protection agency, but it can also be a consultancy. For instance, in the Netherlands, it's often consultancies writing these reports, as long as they're able to carry the impact assessment out in time. So before a decision is made by a public authority, they have to be able to do it so that it can still influence the decision. They must demonstrate that they have competent expertise, but member states can decide how they measure this and how they decide this. In the Netherlands, for instance, if you want to do an ecological assessment, you have to be an ecologist. But to be an ecologist, you can do a one-day online course, and you can call yourself an ecologist. So the requirements differ per country, and they're not always watertight. And you must be able to demonstrate that you do it in an objective manner, although in practice, I think this can be a bit tricky, and I'll show you some examples. Okay, then you have this impact assessment. It's 1,000 pages. And then you as a decision maker, public authority, have to decide, have to scrutinize this evidence. It's of course very difficult. You need certain expertise. There's sometimes also national committees. In the Netherlands, we have a committee, MAIR, Milieueffectreportage. They would provide advice to public authorities on the quality of an impact assessment. But they do this based on the request of a public authority. So if they say, okay, this is a very complex data center with an impact assessment that I don't trust 100%, then they can ask advice from this committee. But it's not mandatory, and it also costs money. Sometimes it can cost 50,000, 60,000 euros to have a check on the impact assessment, per impact assessment. So that can be very costly and can be a bit of a barrier for small municipalities or small government agencies to get this check. So you have a 1,000-page document, and you basically just have to trust what is in there is correct. The public plays a very important role in checking the quality of impact assessments. In the Netherlands, we've had a lot of cases of environmental NGOs who said, okay, the impact assessments are not correct. There was inaccurate information. They haven't looked at this and that. And then sometimes they started legal proceedings, and through judicial review, the impact assessment had to be carried out again. So this sometimes happens, but we talked in the previous presentation about how the burden should not be on the public. Sometimes I feel that it is very much on the public sometimes. Okay. Next slide. Yeah. What has to be assessed? I think if you read this, it sounds really nice, but it's also very tricky and complex. So the direct and indirect effects have to be assessed on population and human health. So let's say you want to build a data center, you have to assess the risk and the effects on population and human health, on biodiversity, on land, on soil, on water and climate. These are all very complex living ecosystems that you have to check the effects on. And then also in their interaction. I personally work in a life science university, so most of my colleagues are life scientists, and the amount of research that they publish on the interactions between biodiversity and climate, for instance, and these complex interactions and our soils and how these things work is incredibly complex. The more we know how difficult this is. And then you have to estimate the effects of certain projects. It's very complex. And how do you deal with this kind of complexity? The Court of Justice has been asked this question a couple of times. European Commission has been asked this question a couple of times. The Commission had a report almost 10 years ago when there were a lot of questions about how to deal with biodiversity and climate change because they change so fast and there's all these new insights. They said basically that impact assessment, the drafters of those reports have to make sure that they avoid snapshot analysis. So they have to look at different points in time. They have to look at both worst case and best case scenarios. So not just say that this is the result, this is what will happen, but look at both worst case and best case scenarios. And also integrate the precautionary principle. These are some insights, and it's of course important, but still imagine that you are an impact assessment drafter and you have to consider the effects of a data center, of an airport, this will still be very complex. So this is the best case of you wanting to deal with complexity. Then there's also some cases where you can see, okay, was this impact assessment really done in the most truthful manner? In the Netherlands, we had some really important cases recently. The government wanted to build a major airport in Lelystad. A lot of people were against it. And then they commissioned an environmental impact assessment. And if you read the impact assessment, basically the airport was amazing. There was no, almost no environmental impacts. In the Netherlands, we have a big nitrogen crisis, but the airport would have no impact on nitrogen almost. And then this ENGO said this cannot be correct. They did their own calculations. They came to very different results. They got in contact with the impact assessment committee. They did a test and they found out indeed all the emission calculations were wrong. Nitrogen was not considered. And then the impact assessment had to be carried out again because it was completely wrong. But if the ENGO had not found, if the ENGO had not found this, then the decision maker would have built the decision, based the decision on an impact assessment that is completely underestimating the consequences. Similar things for a data center. There was a 1,000-page report on the impact of a data center that was planned, but it didn't consider the impact on neighboring Natura 2000 sites. Didn't consider the effects on water systems, on heating, even though the effects of data center on water and heating are huge. And there was also nothing on the use of sustainable energy. So there was nothing about maybe including a few solar panels on those big roofs, etc. And then this had to be carried out again as well because someone caught it. And there was recently a report by ecologists. So these are ecological assessments for instance, let's say you want to build a house and there's a nest of birds there, or there's a possibility of animals there. In the Netherlands, you would have to get an ecological assessment. And there were a lot of ecologists that spoke out because the initiator would come to them and say, hey, can you make an assessment? The ecologist would say, yes, but I know that these birds live there. I know that it's actually very protected. And then they say, okay, we'll go somewhere else. We'll go somewhere else who can make a more beneficial impact assessment. So they shop around sometimes. So this is all very grim. And I'm not saying that everything happens like this. And I'm not saying it happens here. But there were some important cases in the Netherlands where you could really wonder, maybe we need better accountability systems. Maybe we need to make some changes. And then, of course, we need to deal with biases. So I said before, we always choose the same holiday destination, or at least British people do. But we have biases in all our decision-making processes. Even if you want to do the right thing, there's just things in your brain that help you decide, but often it doesn't really steer you in the right direction. So we have systematic patterns of deviations from a norm and reality in our judgments. For instance, a lot of people say women are worse drivers than men. This is something that a lot of people think. I don't think this, but there's no evidence, there's no truth in this. It's just something that a lot of people assume, it's in their brains, and this is a cognitive bias. And there's also unconscious motivational biases. If you want something to happen, you're more likely to think that it will happen. If you want that this airport will not have a bad effect on the environment, then you'll choose for the evidence that confirms this. And as I said, these are hardwired into any decision-making processes. So judges have biases, people making the impact assessments have biases, you have biases, I have biases. And that doesn't have to be wrong, but there are mechanisms so that you can deal with that better and come to a more objective and better impact assessment. Just want to show you a couple of examples. We have the one that is called what you see is all there is. So if you want to, let's go back to the holiday example. If you want to book a holiday, you go on booking.com, you see the first 10 holiday resorts. You think, okay, this is what there is, even though there might be 500 more. There might be 500 other websites. But this is something that, that makes you think that this is all there is. And there's also a lot of research that confirms that if you get a lot of one-sided information, that makes it much easier for you to make a decision. So if all the information you see is that a hotel has 5 stars, 5-star ratings, you think that's amazing, I'll go there. And if there's one review that says, okay, I actually hated it, 1 star, that makes it much more difficult to make a decision. And same thing happens, of course, when you're making an impact assessment. If there's a lot of evidence in one way, it's much easier. But if you have to find a balance between the different informations, it's much more difficult. There's a confirmation bias. So people are often very likely to confirm what they already think is correct. If you think that climate change is not real, then you'll see a snowfall somewhere and you say, see, climate change is not real. because you want to confirm what you already think. This is very, very human. And people often have an optimism bias, so they will often exaggerate the chances of something to happen, even though this might not be the case. These are just some examples, and in the behavioral literature, there's a million of those. And I'll now try to explain why this is so relevant to impact assessment. Because impact assessments can be really a tool where biases are fed and steered in a certain direction. This is just two examples from TV, not from impact assessments, but from TV. And maybe just take a second to think about what might be wrong with them, with both of them. Just take a second and we'll discuss it. Okay, so Carl Tucker, the top one, is never known for his objective portraying of reality. But what do you think is wrong with this specific image? Why might this be, driving your biases?
Percent is not so distant from 77%.
Yeah.
It's so
Yeah.
low.
So the index that they've made starts at 58. Normally, an index starts with 0% to 100%, of course. But now it looks like it has dropped. The amount of Christians in America has dropped in 10 years, but that's not the case. It was 9%. But if you change the index, then it looks like a huge change. So they want to bias people towards thinking, okay, there's way less Christians. It has almost dropped, but that is in half, but that's not the case. What's wrong with the bottom one? That one is easier, I guess.
This one is hilarious.
Yeah, it's hilarious, but it's real. It's real.
Oh.
It's not it was on TV in Venezuela when they had the elections. Of course, the percentages almost differ not at all. But when you see this, if you only take 1 second, you think, wow, Maduro has made an amazing win. But in reality, that is not the case, but it's just how they present the information. Now, with impact assessments, this can often go wrong as well. So a colleague of mine, Eva van Zees, he does a lot of interesting research on behavioral sciences and impact assessments. She interviewed some persons in the committee that reviews impact assessments in the Netherlands. And this person said the following. So sometimes that's the people making the impact assessments, they use colors or smileys, a happy or a sad one, or pluses and minuses. And they do this, of course, to help decision maker to process all this difficult information. But how they reach these pluses and minuses is a trait of its own. Sometimes the text does not relate to the pluses and minuses at all. So, of course, that's a way to feed bias. If you have an airport and the emissions will go up, but you put a smiley and you put it in green, people really respond to colors. Green is something positive. Then you say, okay, that looks quite good. But if you put it in red, then people think, oh, that's really bad. So, and no one has time to read 1,000 pages of impact assessments. So these things can really, really bias the persons having to make the decisions. Okay.
That's infantile.
Yeah, but it's true.
But it's real.
It's real, yeah. All of it is real, yeah. But it's an easy way to feed certain biases, and I'm just making these points because I think that there's also easy ways to solve this or make it better. Okay, some possible routes forward. First of all, I talked about the why of impact assessment. So why do we do it in the first place? And I said the whole system is just based on we want to have an assessment. We have an assessment, and now that's the checkbox ticked. But I think in 2023, there really has to be more consideration as to whether we should not include maybe a stop button. If we find out that a planned data center will have huge consequences on water supplies, like here in Portugal, where you have such water scarcities, maybe then the result should just be we shouldn't do it, as opposed to just leaving that option open. Same like what we have with appropriate assessment. I think that there should be a more serious consequence to negative findings. Then we have to consider how do we deal with complexity effectively, because a lot of these projects, a lot of these interactions, a lot of these effects are so complex. How do we deal with that? First of all, there's a lot of research on the importance of feedback mechanisms. In research, they found out that most people writing impact assessments do this all alone. But if you do it alone, you might miss information, you might misinterpret information. So it's very important to get feedback from peers, maybe inside of your organization or outside, work with universities, these kind of things. And knowledge sharing. I think that it would be really interesting to explore if there couldn't be a stronger role for public participation. So now the public is often scrutinizing reports, saying, okay, it doesn't make sense, we'll go to a court. But what happens if you involve the public more in the impact assessment process? There's a very long tradition of citizen science, citizens collecting information. And I would argue that they often know their local area best. So why not include them in measuring maybe sound effects of airplanes, measuring certain other aspects? So include citizens more effectively. And in this day and age, I think it's really important to embrace complexity a little bit more and embrace uncertainty. If you have an impact assessment that says, this is the right answer, this is what will happen, often we really don't know for sure. So present these best case, worst cases, so that at least the decision maker knows that we're dealing with uncertainty, like the Commission has also said. I personally think it would be really important to also include stronger accountability mechanisms into the process, because the impact assessment idea on paper, I think, is really good. But if you have these cases like what we had with the airport or with the data center, then there's no real use in having this system in the first place. So a couple of things I would say is that, first of all, it would help if every country has an impact assessment committee, made up by independent people that can make checks, random checks to see if reports are actually accurate. This doesn't happen. This is not mandatory in the Netherlands. It's all based on voluntary requests from decision makers. I think this should be integrated, so at least this might be checked. If it is wrong, I might have to do it again. At least there's some sort of oversight, which now is missing. I think it would be really important also to have ex post evaluations. This is not a part of the system yet. It used to be, for instance, in the Netherlands, but it's been taken out as well. Let's say we have this impact assessment for a project like a data center, and 2 years after, we find out that the water usage is 10 times more than what was projected. The heating is 10 times more. Basically, what we base the decision on does not link with reality. Then maybe we should say, okay, maybe the permit should be revoked until they can be more sustainable, at least to have some consequences. I think it would also be important to have consequences for the persons making the impact assessments, maybe a certification scheme where you can lose your certificate if continuously you present, calculations that are not correct, etc., to have a bigger incentive to do the right thing. Because now, in my experience, the worst thing that can happen is that you have to do it again. But if I have students who have to do my exam, and then the worst thing that can happen is they do it again and again and again and again, then there's not really a big incentive to do well. And personally, I think that judicial review should always be sort of the last resort. You don't want to overburden courts, and courts might not be the best place to deal with these kind of documents because it's very complex. They might not have the expertise, but there should still be the possibility to go to a court if all else fails. And then finally, I really think it would be time to consider all this behavioral science. How do we integrate it into the impact assessment process? There's very strong debiasing techniques. Maybe we can make them mandatory into the process because we know this is how people make decisions. We know this is how our brains work. So maybe we should link those in. I'll give a few examples. So this is from the literature, but there's 100 more. One very good way to decrease biases is to increase expertise, both from the persons making the impact assessments as well as the people, public authorities checking the impact assessment. Having more expertise makes it much easier to interpret information. If you have expertise about how percentages work, you'll realize that those images that I showed before with the elections, that they're not correct. But if you don't have expertise, that will be difficult. Nominal group decision-making is a very interesting one. Has anyone heard about this before? Basically what happens, let's say we have to make an impact assessment together about an airport. Lisbon wants to build another airport and we have to make an impact assessment together. Then someone will ask a question like, what do you think will be the impacts? And then all of us take a paper, we write it down before we discuss. And then we compare and then we discuss. So instead of one person doing all the research, one person doing this, you first do your individual work and then you bring it together. So that's a very important way to reduce biases. And frequent feedback loops. Feedback is a hugely important way to deal with biases. You might get feedback from your colleagues, might from external agencies. This is a very, very old graphic or a table from the literature on feedback mechanisms, where feedback is really about making the blind spots, bringing them into the open. Everyone has blind spots, especially or not especially, but also the people making the impact assessments, also the courts, anyone. So feedback loops are very important, and this is an important way and helpful way to decrease biases. Okay, and there's 100 more ideas that you can come up with, and I'm very excited or curious to hear also what you think. This was just a couple of ideas and things to maybe get the conversation going. So I want to thank you for listening to these more theoretical and behavioral approaches, and I'm looking forward to the discussion. Thank you.
Thank you so much, Professor Edwin. Well, I would love to have time to discuss some of these points with you, because this is a different approach. I don't want to take everyone's time, but it reminds me of something I thought when ICG declared impact environmental evaluation as a principle of environmental international law in pulp mills, 2010.
Mm-hmm.
And I thought, wow, what a huge step we have done with this decision. And then I thought, well, but to say this is to ignore that there are so many methodologies, so many pre-comprehensions, so many bias that can disturb how you make an impact evaluation. So to say this is really nothing, because you're not talking about how you make the impact evaluation. You're only talking about the concept.
Yeah.
And the concept can have so many things inside and so many ways to develop.
Yeah.
So I think you really showed us how this can be well, an open box. Everything can fit in an impact evaluation, and all biases. And of course, many times they are not the correct ones.
Yeah.
And it would take us the whole morning. We are on the verge of our coffee break at 11, but I wouldn't like to close the panel without giving the audience an opportunity to put at least three questions. Is there anyone here in the room or in the ether that can contribute to this panel, or wants to share some concerns with us, put some questions? No one going. Okay, well, I would have a million, but in that case, we are going to have our coffee break right now, and we'll be back in 15 minutes to go on with our works. Thank you so much.